Hello, and welcome to In the Privy Council, a weekly podcast reviewing cases heard before the Judicial Committee of His Majesty's Most Honourable Privy Council, brought to you by the Legal Style blog. I'm your host, Elijah Granite. This week we are discussing the Antiguan case of Lux Locations Limited and Yida, the citation for which is 2023 UKPC 3, A and B. This case centers on the question of default judgment, that is, the judgment entered when one party fails to contest a claim. The procedural history of the case is complex. For our purposes, the relevant facts are that Lux Locations are estate agents hired by Mr. Yida Zhong to purchase land in Antigua. Mr. Yida, for various claimed reasons, did not pay the commission Lux claimed they were owed, and consequently Lux sued Mr. Yida. After a lot of litigation back and forth, mostly in Lux's favor, Mr. Yida sued to set aside a previous settlement, or consent order, and have the money he had paid out under it returned to him. On the 23rd of November 2018, Mr. Yida served this rather bold claim on Lux's previous attorneys, who refused service as they were not instructed to accept service. Confusingly, the attorneys shared an address with Lux's own office, so technically speaking, the refused service to the address was valid. Taking advantage of this confusion, Mr. Yida filed on the 12th of February 2019 for a default judgment, as there had been a failure to respond within 28 days to the claim filed on the 23rd of November. The case went to a hearing because the remedy sought of setting aside the consent order was not purely monetary, and thus the civil procedure rules of the Eastern Caribbean Supreme Court, namely Rule 12.10, provides that, quote, default judgment where the claim is for some other remedy shall be in such form as the court considers the claimant to be entitled to on the statement of claim. At first instance, my lady, Justice Robertson, decided in Mr. Yida's favor and gave him the remedy he sought, that is to say, setting aside the consent order and returning the money paid out under it. Things became more complicated when the case came before the Court of Appeal. The reason was that the Eastern Caribbean Supreme Court Act provides, in Section 31(1)(b), that appeals are only possible from, quote, any judgment or order of the High Court. The reason this is problematic is that Rule 12.5 provides that the court office must enter default judgment where no defense is filed, and thus, in the view of the Court of Appeal, the default judgment, even where the particulars were determined by a high court judge, was ultimately an administrative act of the court office, and thus not a judgment amenable to appeal. The fact that the administrative act in this question depended on the act of a judge did not matter, because Rule 12.6 provides that any action taken by court staff may also be taken by a judge. Thus, Lux lost. However, the Court of Appeal, recognizing the great public importance in clarity on matters of default judgments, granted leave to appeal to the board, where we resume the case. For the board, my lord, Lord Leggatt began frankly, quote, the proposition that the judgment and order of Justice Robertson, supported by some 14 pages of reasoning, is not a judicial decision, is a startling one, which the board is unable to accept. There is, in the board's view, no justification, as a matter of language or otherwise, for regarding a default judgment granted by a high court judge under Rule 12.10(4) as outside the scope of the phrase, any judgment or order of the High Court, in Section 31(1)(b) of the Act. This is a striking rebuke to the Court of Appeal, and one which the board founded on the plain language of the rules, namely, that Rule 12.10, quoted earlier, requires that where a default judgment wants a non-monetary remedy, a judge, and only a judge, must determine what remedy is fit. Court staff cannot determine the proper remedy, which is a task for a judicial officer alone, and thus it was very plain to the board that necessarily the first instance judgment of Justice Robertson was amenable to appeal. The counter-argument put by Mr. Yida's counsel that the court office first grants the default judgment, and the remedy following that judgment is then afterwards determined by a judge, but that is not itself a judgment, was, in the view of the board, incoherent. To quote Lord Leggatt's memorable sports metaphor turn of phrase, quote, "A judgment which, as yet, has no terms is as empty a concept as a book with no pages, or a football or cricket team with no players." The next question for the board was how the court should approach the claim in default judgment proceedings, namely, if review on the merits was permissible, or if all the allegations in the claim should be stipulated as true. The general rule, very well established in English authority, is to simply take all the claimant's assertions as true, rather than try to assess them on the merits. For example, see Brett Wilson, LLP, and Persons Unknown, 2016, 4 WLR 69, QB. The board accepted this rule, but added two important qualifications. First, the English authorities concerned cases where the defendant was not contesting the default judgment, unlike in the case at bar. Second, this rule was a general principle, not an absolute rule, and the court retained the flexibility to depart from this rule where it appeared the claim in question was an abuse of process, or did not even disclose a legally recognizable claim. This discretion was very long established. The board pointed to a consistent line of English cases, beginning in the 19th century with Charles and Shepherd, 1892, 2QB 622, CA. As the Eastern Caribbean rules are modeled on the English rules, the case law was persuasive here. As for the question of a defended default judgment application, the board noted that there was a long-standing ambiguity in English law about if a late defense precluded default judgment. England resolved this in 2020 when CPR 12.3 was changed to provide that default judgment could only be obtained where no defense was filed by the date the judgment was entered. The Eastern Caribbean has not made such an amendment, but the board reasoned that because the rules provide at Rule 13 a procedure to apply to set aside a default judgment, it would be wasteful to require that the defendant wait for the default judgment and then commence new court proceedings to set aside if the court already had, by the time it was entering the default judgment, the defense before it. Here again, there was a long line of authority supporting this proposition, going all the way back to the ruling of the Lord Chancellor, the Earl of Selborne, in the case of Gibbings and Strong, 1884, 26 CH, D 66, CA. Thus, the board came to the conclusion that where there are grounds before the court which justify setting aside the judgment, default judgment should not be granted, regardless of formalities. Equally, the presumption of validity of claim accorded in default judgment proceedings could not extend to claims which were abuses of process. Applying this reasoning to the case at bar, the board overturned the Court of Appeals decision, and to avoid further delay, took the unusual step of deciding the underlying issues itself, rather than remit the case. First, the board determined that Lux ought to have been granted an extension of time due to the confusion around service to make its defense, and that the defense had a real prospect of defending the claim, and would have anyway justified setting aside the default judgment. Further, Mr. Yida's attempt to undermine the consent order on the pleaded grounds of non est factum was legally completely unfounded and could not possibly be proven or demonstrated as a legal claim, and was, to quote a famous decision of Lord Watson, Lawrence and Lord Norrie's 1890 15 Appcast 210, a tissue of improbabilities which ought not to be sent to proof. Further, the multiplicity of suits filed by Mr. Yida suggested abuse of process, indeed a, quote, textbook example of abuse. Consequently, the board humbly advised His Majesty to allow the appeal in Lux's favor. Turning to our analysis of the case, this case demonstrates, in my view, the holistic approach courts take towards procedural questions. Going purely by the absolute letter of the rules, it's possible to see how default judgment was entered here, despite the late defense, and to a lesser extent why the Court of Appeal denied that appeals could lie against the decision entering default judgment. But this narrow approach misunderstands the role of the court. The judge is not an automaton, simply stamping default onto a claim form, but rather the master of the proceedings, endowed with the discretion to determine when a late defense can properly be admitted, or if the normal rule on presuming a claim in default cases should be followed. All the rules are interpreted in favor of the overriding objection, codified or not, of advancing the administration of justice, and so an abusive claim, as here, will not find that the rules provide shelter. This principle can be seen in the unusual disposal of the case, by which the board departed from the normal practice to directly resolve the issue instead of remitting it to the lower courts. This action was justified in the round because the abusive and frivolous nature of the claim meant further procedural delay would only reward Mr. Yida's abuse of court process. In the end, rules are there to serve justice, not the other way around. Thank you very much for listening to another episode of In the Privy Council, brought to you by the Legal Style blog. If you want more legal content, visit our website, legalstyle.co.uk, or follow us on Twitter, @LegalStyleBlog. If you have any comments, suggestions, rants, or raves, the email of the podcast is editor@legalstyle.co.uk. We also welcome any ratings or reviews on your usual podcast platforms. Until next time, goodbye, and God save the King.